Our second case scheduled for oral argument this morning is the Department of Business and Professional Regulation versus the Florida Horsemen's Benevolent and Protective Association. Is counsel ready to proceed? Yes, sir. You may approach counsel. Counsel, we allocated 15 minutes per side for the oral argument in this case. Would you like to reserve some time for rebuttal?
Yes, Your Honor, 3 minutes.
So noted, Madam Clerk. You may proceed, counsel.
Thank you. May it please the court. Good morning. Ross Marshman on behalf of the appellant, Department of Business and Professional Regulation, Division of Pari-Mutuel Wagering. This case is about what the legislature wanted the department to adopt for its classification scheme and penalty schedule for drugs or other substances in racing horses in the state of Florida. During my argument, I will answer that question and explain why this court's opinion will still have an impact one way or another. In other words, why this case is not moot. This case involves really one statute and one rule. In 2015, the legislature amended Section 550.2415, subsection 7C, and directed the division to adopt a classification system and penalty schedule, which incorporated a portion of the Association of Racing Commissioner International's Uniform Classification Guidelines for Foreign Substances. In response, the division adopted Rule 61D-6.011. That rule included a classification system and penalty schedule. The classification system in that rule matched the one in the ARCI document. The penalty schedule was something the department came up with on its own. In this case, the language of the statute is clear and unambiguous. There is really only one way to reasonably interpret the language of the statute. The division was specifically directed by the legislature to adopt ARCI's Uniform Classification Guidelines for Foreign Substances and create a classification system and accompanying penalty schedule which incorporated that portion of the document. In this case, the ALJ ignored the actual language of the statute. Specifically, the ALJ read the statute as if it states the division was required to adopt the full ARCI document. That is incorrect. Now, the full title of the ARCI document in this case is found on page 19 of the record. The title is...
Sorry, the title of what?
The full title of the ARCI document.
Okay.
Is found on page 19 of the document.
That's the Uniform Classification Guidelines for Foreign Substances, is what you're talking about?
I'm referring to that, but that's not the full title of the document.
Okay.
The full title is the Uniform Classification Guidelines for Foreign Substances and Recommended Penalties and Model Rule. And again, that full title is found on page 19 of the record. The ARCI document itself is comprised of multiple sections. There's a classification system, which is found on page 25 to 26 of the record. There's a substance list, both alphabetical and by category. That's found on page 27 to 52.
Can I ask a question?
Yes.
I want to make sure I'm understanding the crux of the argument here, but I mean, I understand it, at least this far, that there is a document that includes these different components, the list of prohibited drugs and the penalty schedule. And their argument is that the legislature required the agency to incorporate both of those elements of the one document. And your argument is the legislature only required the list of drugs and left open what the penalties would be. Is that, do I have at least that much right?
That's correct.
Okay, and then what you're saying now, and I don't mean you're saying now in terms of inconsistent with what you've said before, but what you're saying is that the Uniform Classification Guidelines for Foreign Substances version 8.0, which is what the statute says, is not the full document title of this document that I assume everyone agrees, whatever document we're talking about, right?
Correct, Your Honor.
Is there a document, though, that is called just Uniform Classification Guidelines for Foreign Substances version 8.0? I mean, I understand you're saying that's not the full title of the document, but there's not some other document that just includes that title, right?
Yes, Your Honor.
Okay.
There's no separate document that only has that title.
Okay. And so your argument would be by using half of the title and not the entire title, that's what makes it clear that the legislature did not intend to use a component of the document that they're referencing there?
That's a portion of the division stance argument.
But there's no question about what document we're talking about here, right?
That's correct.
So the legislature is pointing to the document. And if they'd used the full title, you would agree with opposing counsel that or would you? I mean, if they had used the full title, would that change your legal position here?
So if the legislature had directed us to adopt the Uniform Classification Guidelines for Foreign Substances and recommended penalty and model rule and used other different articles in its statute to direct us to it, we would have adopted that originally in our rule. Yes, Judge, to answer your
Okay.
question. So moving aside from the title of the document itself, it is important to examine the language of the statute. The division was required to adopt a classification system and a penalty schedule, which incorporated a portion of the ARCI document, which is the Uniform Classification System for Foreign Substances. The division was not directed to adopt the penalty schedule from the ARCI document or adopt the entire ARCI document itself. The division did not have to adopt, in other words, the ARCI's penalty schedule. The legislature gave the division discretion on which one to adopt.
Well, they had to adopt a corresponding penalty schedule which incorporates the Uniform Classification Guidelines.
Correct. The division maintains that so long as its classification system and penalty schedule were related and incorporated the classification system from the ARCI document, then that would be a permissible penalty schedule.
Okay, so that you could do any penalty schedule so long as it incorporated the classification guidelines, but not necessarily the penalty recommendations in that document.
Yes, Your Honor.
Okay, I'm getting a better understanding here. Is the document version 8.0 that was revised December 2014, was that the entire document? I mean, is there some, one component is, you know, the classification component was revised at a different time or different version numbers or anything like that?
So at the time the statute was passed in 2015, that was the most up-to-date version, if it's referencing the entire document. Since then, the document has been amended, I think, every year after that.
Okay.
There's other language elsewhere in section 550.2415 that shows that the legislature only meant for the division to adopt the classification system and not the penalty schedule. For instance, in
Counsel, I believe I understand your argument in reference to the title. We're looking at the statute as a whole, Why isn't it clear that the legislature intended that the penalty portion of the ARCI document be incorporated?
So from a reading of the statute, the division believes that the use of indefinite articles in the statute means that the division did not have to adopt the penalty schedule from the ARCI document. Specifically, the legislature directed the division to adopt a classification system and a penalty schedule.
But you agree that the classification schedule that they had to adopt was the classification schedule from the document, right?
Correct,
And
because
it says A as well.
correct. However, the legislature continued and specifically directed the division to the portion of the ARCI document that contained the uniform classification system. So the division believed that we could only adopt a classification system that matched that portion of the ARCI document.
Right. I mean, that's your whole case, whether they were referring you to a portion of the document or whether they were referring you to the document. Right? I mean, is that the whole case?
Yes, Your Honor.
Other than the mootness issue, which I know is a separate, okay.
Other than mootness, Your Honor, yes, this case does turn on the language that was used and how the division was directed in this case. So returning again to the statutory language of section 550.2415, subsection 7C, aside from subsection 7C, there's two other provisions, I think, that should impact this case. One of them is, it's actually 3A, which states that the maximum fine that the division can impose for a violation of that section is $10,000 or the amount of the purse, whichever is greater. In the penalty guidelines of the ARCI document, there are numerous instances where the maximum fine exceeds that $10,000 threshold. It's $25,000, $50,000. So there is a conflict between the language in the statute and the penalty provisions in the ARCI document, which the ALJ believed should be part of the rule. The ALJ applied canons of construction in this case. Specifically, she applied the doctrine of last antecedent. But in applying that doctrine, you would have to believe that, one, the language is not clear and unambiguous, which the division maintains it is, but also the ALJ added an otherwise missing phrase to the statutory language. Again, the ALJ added the missing recommended penalty and model rule from the title of the document. And without doing that, the doctrine of last antecedent wouldn't actually change the language of the statute in the way the ALJ says that it does, unless you add that otherwise missing phrase.
Counsel, you're getting close to your rebuttal time. However, you haven't addressed the mootness issue. Why is this appeal not moot?
So, as it stands now, the division has approximately 90 or so disciplinary proceedings based on administrative complaints that were filed when the previous version of this rule was in effect. Whether this court affirms or reverses the underlying case, those disciplinary proceedings will live or die, so to speak, based on the outcome of this case. So, for instance, if the ALJ's order is reversed, then those disciplinary proceedings will be allowed to proceed. If it's affirmed, the department will have to vacate or otherwise dismiss those ongoing disciplinary proceedings.
Can you address the issue of agency deference in light of the recent statutory amendment that was effective January 8th?
Given the language of the amendment, the division believes that no deference is no longer owed to the agency's interpretation of the statutes to which it is in charge of enforcing.
Sometimes when an appellate court dismisses an appeal as moot because of changes that have happened below, they'll vacate the underlying order. And if that happened, then you could litigate the validity of the rule in those individual disciplinary proceedings, right? And it wouldn't involve this challenger, the association. Tell me how that would work, or why that wouldn't resolve your issue.
I'm not sure I agree with that completely. I believe if this court affirmed the ALJ's final order, which ruled that 61D.6011 at the time was an invalid exercise of delegated legislative authority.
Oh, I agree with that, if we affirmed. I'm saying if we found that the issue was moot and dismissed the appeal, because the way this originated is you had an association that was challenging a rule. The association is now satisfied. It was, their case, their challenge. And what I was saying is sometimes when the appellate courts dismiss an appeal as moot, and at the same time they will vacate the underlying decision, which has also become moot. And so that would, I guess, and I'm not suggesting that's the correct result here, but that would then allow the issue to be litigated to the extent it needs to be in the individual disciplinary proceedings.
I believe the division still has its obligation to ensure the health, safety, and welfare of the animals that are racing in this state. So if this case was dismissed as moot based on the subsequent amendment of the rule, which does include the ARCI schedule penalties now, I believe we would still be obligated to litigate that.
Oh, no, you would, maybe I'm not being clear. I'm saying the validity of the rule, your point is whether the rule is valid or invalid obviously matters to the cases that involve disciplinary proceedings against people who violated the old rule, right?
Yes.
And so those people could challenge the rule, or, as a defense, and the validity of the old rule could be litigated in the context of those disciplinary proceedings, which is the only place it matters now.
Yes, I would agree with that.
Okay.
And with that, I would reserve the remaining time for my rebuttal.
Thank you, Counsel.
Good morning, Your Honors, and may it please the Court. Bradford Bailey of Bailey and Strossel, Fort Lauderdale, Florida, on behalf of the appellee, the Florida Horsemen's Benevolent and Protective Association, with the acronym, if I can use it with the permission of the Court, of the FHBPA. It's just simpler. Your Honors, this is a really interesting appeal, and it comes to this Court in an interesting posture. We have a partial final order because still below is the claim that the statute that they actually utilized, and then the rule that was actually adopted was arbitrary and capricious. It's still down there. We're also sitting here with a case that the underlying rule is now moot, and it's moot based in part by the division's acquiescence to the claim of the FHBPA that they were required to adopt the full document, which, as Your Honor pointed out, is the only document. As part of the record, you'll find a couple of admissions by the agency that they knew that they were supposed to adopt the full document. You'll find that in their landing webpage, it's in the record at page 300, and it said that the division had adopted the full document by rule, by its title, in full, i.e. Uniform Classification Guidelines for Foreign Substances and Recommended Penalties and Model Rule, right on their website. Because if you go into the legislative intent, you'll see that the legislator was trying to bring Florida into the 21st century in terms of its medication rules and in terms of its guidelines for both medication classifications and penalties. It's actually within the legislative intent and part of the House bill that they noted that we hadn't changed our regulations since 1990, and that all other states had adopted portions of the ARC document to try to achieve uniformity in the rules. So when I say it's an interesting posture, we're here in a posture where we know what the legislature intended. We're here with what did the legislature intend when promulgating Florida Statute 550-2415, sub 7, sub C. They intended, without question, and it's in the quotes from the record on page 289, 294, that's from the Senate bill, and 282 and 285 from the House bill. It's undisputable that the legislative history required the incorporation of the ARCI penalty guidelines as part of the statute. So we know what the legislature intended. The question for us now is whether the language used by the legislature, given the plain and ordinary meaning of the words used, clearly and unambiguously manifests that legislative intent. Now, what's interesting is, of course, the division says it's clear and unambiguous and it manifests one intent. The FHBPA says it's clear and unambiguous and it manifests a different intent. And what we point to in our brief is the only place you actually see the term Uniform Classification Guidelines for Foreign Substances and Recommended Penalties and Model Rule is in the title of the 39-page document. Every other page, every other subsection has on the bottom left-hand corner, and I know you have this in the record, the language, quote, Association of Racing Commissioners International, Inc., Uniform Classification Guidelines for Foreign Substances. That is the short-term industry use of this particular document. That language is also on the 4 pages of the penalty guidelines. So on the bottom of the penalty guidelines, it's still referring to Association of Racing Commissioners International, Inc., Uniform Classification Guidelines for Foreign Substances. So
in fact, there's no document that has a formal title that matches perfectly to what's in the statute. Is that right?
Correct. Correct. And that may lead you to the question of, was it ambiguous? I know counsel didn't address that. You didn't ask counsel, but if the reasonable interpretation would be there's no document that just has the title of what the statute says, and then the legislature mandated a document, mandated a certain term, the regulator picks up the document, and the first thing the regulator sees is the title, Uniform Classification Guidelines for Foreign Substances and Recommended Penalties and Model Rule. Does that lead the regulator to instantly conclude, wait a second, what is it the legislature is asking us to require? What is the legislature asking us to adopt, because we now have a document that has additional words in its title? If you look in the document, then you see that we have on the bottom left-hand side of every page, as we've described to you, all the references to the short form title that the ARCI uses for its document. What you would then do, if you were going to actually go and say that made it ambiguous, if you're the regulator and you really want to know what the statute required us to do, you're the Division of Pari-Mutuel Wagering, you then go look at the legislative history, and you go look at those sections that I quoted to Your Honor that make it abundantly clear what the legislature did intend. So you're left with the issue of why are we also here now because of the mootness, and I want to address that. We ended up with, it's part of the record and the motion to dismiss is moot. It's not part of the record of the underlying appeal in front of Judge Nelson, but subsequent to Judge Nelson's ruling on the partial final order and this court accepting jurisdiction while leaving the arbitrary and capricious argument below, the division came up with a second version of a proposed penalty rule, 6.001. The FHPPA immediately filed a rule challenge saying, here's Judge Nelson's order. Judge Nelson's order is very clear. You're supposed to adopt the full penalty guidelines of the ARCI as part of the document. What the division did next was they filed a notice of change that, and a motion to abate that basically required the division to then adopt the full document. And in the document and in the notice of change, they specifically say that you need to adopt, they still call it the Uniform Classification Guidelines for Foreign Substances, version 8, but the hyperlink now takes you to the full document, and it incorporates both the classification guidelines and the recommended penalty
And that
guidelines.
resolves all of your issues.
Excuse me?
That resolves all of your issues, the new rule.
Absolutely.
And
So-
is that, and I'm not familiar with the severed claims or your arbitrary, it resolves all of that too, everything that below, or just the issue that's here?
It resolves the issue here. The arbitrary capricious issue is not, the reason it was originally bifurcated was because if the judge ruled that they were supposed to adopt the penalty guidelines, then there was no reason to necessarily deal with the arbitrary and capricious issue, because they would basically concede that they had to rewrite the document and adopt the ARCI
So the new
penalty
rule
guidelines.
resolves all of your issues from the original claim, both those that were subject to the partial final judgment that's on appeal here and those that were remaining below? Or do you still have other issues in that? And maybe this doesn't matter, but
No, we actually,
do you understand my question about the,
sure.
okay, so you brought a claim that this was an invalid rule. You succeeded on that, and we're here on that appeal. And you also had this other claim that you're talking about this arbitrary and capricious. Was that resolved by virtue of the new rule as well, or is that a completely independent issue?
Well,
That's nothing-
it was an independent issue in the sense that there was an argument to be made if they were not allowed to, or not required to adopt the full penalty guidelines. There was still a reason that it was an invalid exercise of delegated
As
legislative
to the
authority.
old. But when they adopted a new rule, did that resolve?
Well, Judge Nelson's under the belief now that this case is up on appeal is that she can't do anything with the
Okay.
second part of the case.
Well, let me ask this. I wonder if you could respond to their argument on the mootness about the importance of this issue as to the disciplinary proceedings and what happens to those, or what happens to anything if we dismiss this case.
Well, I believe, to be candid with the court, that there's a decision that does support the argument of the division. I have it over here. I think it's called Arias. You can't punish if you don't have a set of guidelines.
Right.
So if for a specific alleged violation, if you don't have a guideline, then you can't punish and the case has to be dismissed. So the argument that they're making, which makes some sense, is that if we throw out the old guidelines because they never should have been adopted to begin with, then there were no guidelines in existence during that period of time. New guidelines don't apply retroactively, and the cases need to be dismissed. If that answers your question.
Well,
I'd like to say that it doesn't have the effect that they claim.
I think what they're arguing is that there's a collateral consequence. I think, and correct me if I'm wrong, but I think there's, but for these intervening disciplinary proceedings, I think they're saying that there's no other reason not to dismiss it. But that's the reason not to dismiss it, and that's a kind of a collateral consequences kind of argument. And I guess the consequences to the agency would be their inability to prosecute these cases.
Right.
And so my question to you is, what is your response to that in not their ability if the rule's invalid, but what we do in this case in terms of dismissing as moot or not dismissing as moot and reaching the merits.
I think that the court needs to reach the merits.
Okay, so because you had suggested in your separate motion to dismiss as moot, and you're withdrawing that request.
Yes, Your Honor, at this
Okay.
point in time, in recognition of what the division has said and doing the research on that issue, I think the Arias case would lead to those 150 cases having to be dismissed because there were no effective guidelines at the time.
Okay, and what was the, would you mind?
I don't mind at all. It's Arias Division of Real Estate. It's 710 Southern 2nd at 655.
Thank you.
My pleasure. I still believe that once you read the merits, that we're not going to be there anyway, because the guidelines that they adopted are just not appropriate guidelines. And I talked to you about the admissions. I talked to you about the webpage. I talked to you about the notice of change. And if your honors look at the current rule, okay, they still refer to the Uniform Classification Guidelines for Foreign Substances. It's in the appendix to our motion to dismiss as mootness, and your honors can certainly take judicial notice, as we've asked, that it's simply a hyperlink now to the full document, which your honors has said originally, are there any other document, and says no. It's just a hyperlink to the full document, and it actually says in the statute that we are required by the statute So this is now in 61D-6.011. In accordance with Section 550-2415 the Uniform Classification Guidelines for Foreign Substances, version 8.0, revised December of 2014 by the Association of Racing Commissioners International, Inc., is hereby incorporated by reference. An electrocopy is available with the hyperlink. So it's an admission now, because nothing's changed in the statute language, nothing's changed in the document, but it's an absolute admission because now they require the full document and say to follow it. So I don't know if the court has any other questions for me. I know I have a minute and 30 seconds, and I'm happy to respond to any question that your honors may have.
None, counsel. Thank you.
Thank you, Your Honor.
May it please the court. In the brief time I have remaining, I'd just like to address the subsequent amendment and change to Rule 61D-6.011. The division pointed out in its brief long ago that it was planning on adopting a modified version of the rule. And as of September 2018, we do have the ARCI penalty schedule incorporated in our rule. However, to the extent the appellee argues that this is some sort of admission, that's reading too much into the department's decision. Again, the division maintains that it had the discretion to adopt a penalty schedule in this case, so long as it was related to the classification system that was incorporated, the portion of the ARCI document, which is the Uniform Classification Guidelines for Foreign Substances. We did not adopt that necessarily because we now think that we were always required to do so. We still respectfully disagree with the ALJ's conclusion in this case. And to the extent that legislative history plays any role in this case, that is only if this court believes that the language of the statute is not clear and is ambiguous. And in the legislative history in this case, in the summary of the analysis, it does state that the division was required to adopt basically both parts of the ARCI document. However, in reading the actual analysis itself, the long form, it's less clear then what the legislative analysis actually says about what the division was actually supposed to adopt in this case. So I would encourage the court to review that legislative history towards the end of the record from pages 280 and on.
If we find it ambiguous. But your lead position is that we ought not to look at the legislative history at all, right?
Absolutely, Your Honor. The division maintains that for the reasons we've discussed today and for our briefs, this court should reverse the ALJ's partial final order. And if this court has no further questions, I would sit down.
So for the sake of argument that we find that the statute is ambiguous, should we give the department's interpretation of the statute any deference?
Based on the constitutional amendment and the change to the Florida Constitution, I don't believe that the division can maintain that it is owed any special deference to its interpretation of the statutes that is in charge with enforcing in this case.
Thank you, counsel.
Thank you for your time.
This concludes our oral arguments for this morning. We stand in recess.
All rise.